It's not right to develop the common law. It is sometimes appropriate to make remarks which other courts used afterwards to develop that.
In instances where there are divergent views, as the judge who possibly could be appointed on cases that you are dealing with in a panel, how are you going to deal with disagreements? And how are you going to ensure you maintain the independence as a judge, but also leading a panel, of course?
You do that often when you in the High Court and you're the senior judge in an appeal with two. Sometimes people have very strong views opposing you, or you might have strong views. There's nothing wrong with that. That's what we meant to do. We meant to make our points forcefully if necessary, but always respectfully. And you must always be able to then write a dissenting judgment. Yeah.
Chief Justice.
Thank you, Minister. Commissioner Kane.
Thank you, Chief Justice. Good morning, Ms. Bartman.
Good morning.
Have you had an opportunity to carefully consider the review that was presented by the GCB?
Yes, I have.
Now, in that review, they raise a couple of things. The one is that you hadn't supplied your date of birth,
Yes.
and the Chief Justice took that up with you, and you said it was required to be done in an Annexure A.
Yes.
I also spent some time looking for Annexure A, and whatever is attached to your application doesn't seem to deal with that question. Are we missing something?
I don't know, but there was a loose annexure, and that asked for my personal details. In fact, I have a copy, and I'll hand it up.
Thank you. Perhaps I can have a look at that just now.
CJ, I wanted to propose that the candidate bring the mic closer to us. So that
Just bring the mic closer to you, Judge Bartman.
I should move closer.
You
to the
can't
mic.
pull it forward.
Yeah.
We don't want you.
Okay. Is
Hitting
that
your
better?
back.
Okay. I have annexure A here.
Thank you very much. I'll certainly
It
have a
has
look at that.
My name, my cell phone number, residential address, and ID.
May I take you then to matters of some concern in the GCB's report? They have traversed a number of your judgments, and what they raise are issues pertaining to judgments you gave. They say that you dealt, for instance, with an issue of prescription without having any of the primary facts before you. They say that you misunderstood the nature of discovery and what the purpose of that was. They say you really misconstrued what would have been a condition and took into account completely irrelevant considerations and veered off course, and that your conclusion was legally untenable. Those are criticisms you would have seen, and I would like you please just to deal with that and persuade the Commission that in these areas of civil law, that you do indeed have sufficient experience to deal with those kind of aspects.
Okay, thank you. Can I deal with the matter of Grootkraal first? In Grootkraal, it was a matter of mine that was upset. If you go to paragraph, you might not have the judgment in front of you. I have the appeal judgment in front of me. And paragraph 20, sorry, just a minute. Paragraph 20, the court sums it up. The court says, Grootkraal's history is bound up with the history of the missionary activities in this part of South Africa. And then he says, the parties dealt with this on a relatively cursory basis. In the result, some of the assertions made were more the product of legal drafting than historic facts. And then the court proceeds on paragraph 21. It says, much of what follows is drawn from these sources and has been used to complete the correct picture drawn by the parties in their affidavit. Now, this is one of the matters that I was upset. But if just look at paragraph 20. Evidence was placed before the court on appeal that I did not have. I could not possibly have reached the same conclusion with different evidence. That's the one that I just want to deal with. And then the other one is the matter of Claire Howman and the Kingsbury Fetal Assessment Centre. Was also a matter that went to the Constitutional Court, and what happened in that matter, the matter came before me as an exception to pleadings. The normal order would be, if you uphold the exception, is to send the parties back to deal with it. I was specifically asked, do not give the normal order, because the year before, the Kingsbury Fetal Assessment Centre and another party went all the way to the SCA. At that point there, they were sent back. Now they had another patient and they wanted to test the same proposition in the Constitutional Court. So the Constitutional Court said, I should have criticized me for not giving the usual order, meaning give them an opportunity to amend their pleadings. But I was specifically asked not to do that. And you're dealing with a fetal assessment center, you're dealing with unborn children. It was necessary to test that proposition in the Constitutional Court, therefore that order, just to deal with that one. You have then raised the other issues that I've looked at those cases. One of the matters that's before me, you must understand, if the matter is presented as a prescription issue to me, that is what you deal with and that is what you answer. I take the criticism that on appeal the matter is upset. That happens, but it doesn't mean that you didn't know what you were doing. We get it wrong from time to time. In the church matter, the Lutheran Church, there you had a poor community. They've had that church. They fell in arrears. The place was falling apart. They came to court. They had a plan, they couldn't go to a bank and borrow money to get the church and the school going. They asked for an opportunity. There were negotiations between them and the municipality. So if the court says she took other considerations into consideration, that is correct. That is what happened on the day the law is not just tick boxes. You're dealing with people, and sometimes you go too far. This Grootkraal matter is such a matter where the appeal court went and found the records that the parties did not put before the High Court. I hope that answers your question.
Thank you. You've certainly given good answers. Do you want to also deal with Caxton and the discovery aspect?
Caxton matter, you must remember those parties are actually opposition parties, and the one party purchased some of the other parties' they purchased some of their stocks, so they were now a party to it. And it's on that basis that they were fighting all the time. And the senior company was going into litigation with basically one of his shareholders because they bought some of the shares. And it's from that perspective that I said, but there is preceding spending. The main company is going to institute litigation against you, and the appeal court said no, but they are parties and they are entitled to it. So, yeah.
Chief Justice, may I just also place on record that the candidate has produced a document which has the heading Annexure A, and it appears that it may have been omitted from our papers. It doesn't bear the birth date, but it does have the identity number.
Thank you, Commissioner Kane.
Thank you.
Okay. While I have my finger on the report which Commissioner Kane has just questioned you on, let me ask just to bring something to your attention and find out if you would like to comment on it. I agree with Commissioner Kane that the responses you've given in explanation for these judgments of yours that were overturned is all explanations are good, but the concern that is expressed is that of the 18 judgments of yours that have been taken on appeal, a majority was overturned.
This is why
Out
I
of
say,
18, a whole 10 was
Yeah.
was overturned.
but the the Kingsbury matter, if I didn't think of some other considerations than my career, I would just have sent them back to the drawing board. But you take the risk because we needed the Constitutional Court to say something on the issue. And in the other matter, I didn't have the facts. So I could not have granted that order minus the facts. In fact, the parties didn't have it. The court found it.
No. I was hoping you would also say that you've written many judgments over the years which were not taken on appeal and still stand. So we can't judge you by the 10 that you happened, well, someone thought you got wrong.
Yeah, and it's 15 years,
Yeah.
I must say. We write many judgments every day.
All right. Thank you, Judge Bartman. Commissioner Tsweni?
No, thank you very much, Chief Justice, and good morning to Judge Bartman.
Good morning,
I
Commissioner.
think we've dealt quite extensively because one of my concerns was also around your judgments that were overturned, and I'm being persuaded by the discussions that ensued here. But over and above that, we've heard earlier on that you've been with the Supreme Court of Appeal. That has obviously earned you quite a bit of experience in that regard. I just want to know, added to that, what is it that has motivated you to apply for this position?
I have been on the bench for a long time, since 2008 when I started acting. You assess your judgments, what comes back from it, and your own readiness. And in 2015, having done a year there, I was then persuaded, and am still now, that I am ready to make the contribution that the court needs at this stage.
No, thank you very much, Judge Bartman. Thanks, CJ.
Thank you, Commissioner Mtsweni-Sipane. Commissioner Kotsa?
Thank you, CJ, and good morning, Judge Bartman.
Good morning.
You spoke about developing the common law earlier,
Yeah.
and in what is known as the Dalai Lama matter,
Yes.
which is a pretty old matter by now, the SCA overturned your judgment and considered that the question of whether or not the authorities had acted lawfully was and remained a live issue. The General Counsel of the Bar thereafter then commented on your judgment and said that the judgment appears to be indicative of the candidate's tendency to apply the law somewhat mechanistically, and they also said that you've not used the opportunity on the facts applicable in certain cases before you to develop the common law. This was around about 2018. So my question to you, has there been a concerted effort since then to focus on these comments, and in particular to develop the common law?
Okay. Thank you. Can I reply like this? I was one of two judges on that bench. The facts in front of us was what we dealt with. As I indicated earlier, if you want to develop the common law, it must be done case specific. You must have the facts to do that. You cannot just develop the common law in a vacuum. And you cannot apply the law mechanically, really. That is why I got into trouble with the Lutheran Church, because had I just applied it mechanically, and also with the Kingsbury matter, then it wouldn't be held against me. So, thank you.
Commissioner Hassan?
Thank you very much, CJ. I'm over here. I know it's
Hi.
a little
Good morning,
difficult to find
Commissioner.
all of us. My name is Fasia Hassan, new commissioner for the JSC from the National Assembly. Judge Bartman, I'm going to cover somewhat of a less technical matter, and it's related to the Boyson case, though unreported. And I found it very interesting, Judge, your approach to centering victims' voices, and the manner in which there was an attempt to, I think, craft for the survivor by the perpetrator their response. And so my question really is, do you think that this particular area of law has developed sufficiently to help combat GBVF? But I'm also interested in your experience and your work in the sector, both in the earlier part of your career, which we've read about, but also now, and what you think needs to happen in terms of furthering the process for centering victims and survivors of GBVF. Thank you.
Thank you. There is a lot of work that still needs to be done. From the court perspective, what we can start doing and are most certainly encouraging is for people to speak up. Therefore, that judgment says the abuser cannot tell the victim how to complain. Our courts are still crowded. You come to court and it's secondary victimization sitting there the whole day. They opposite you. Honestly, a lot has been done on the ground in the lower courts. People are paying attention to those issues. We have space issues at courts. That is a problem. You're dealing with a relatively high turnover of clerks, not specialists in the field. That is another problem. What my personal experience, what I often see, is that there's no counseling which should actually be attached to the court, that center. I don't know, the money isn't there, the accommodation isn't there, but that is most certainly needed and can be done. Okay, thank you.
Thank you. Any further? Commissioner Maiman?
Thank you, Chief Justice. Greetings to you, Judge Bartman.
Good morning, Commissioner.
Just two from my side. The first one relates to the fact that indeed it is not for the first time that you are here.
No, it's not.
So therefore, I think the first question will be, what is it that you want to give to this panel that will make a distinction between the previous decision and the new decision that will elevate you to the Supreme Court of Appeal, given the fact that the last time you were not successful. The second one relates to given the departure of senior justices from that Supreme Court of Appeal, either through elevation to other more senior position, like the CJ, and also the other through retiring, like the Deputy President, Pete. The question that I want to pose to you is, what are the unique contributions and value adds that you will be bringing if you are appointed to the Supreme Court of Appeal, given what I've alluded earlier on? Thank you.
Okay, thank you. Thank you, Commissioner. The Supreme Court of Appeal have lost a lot of experience. What they need is a judge that you can say there's a 60-volume matter, get on with it, and get on with it. That's what they did to me in December. I got on with it. They need people who can hit the ground running. After 15 years on the High Court bench, a very busy court, and we all know our court is busy. I can do that. That is what I bring, a willingness and able to work, and that's what that court needs.
Thank you, Judge Parkman. Thank you, CJ.
Commissioner Balui?
Thank you, CJ. Good morning, Judge.
Good morning,
Yes,
Commissioner.
Judge, to go back to the GCB comments. Now, they comment that the Chief Justice has spoken to you about the number of appeals, matters that were taken on appeal, and what the GCB says about it. Now, I think you should at least have the opportunity to comment on this.
If you can just stay behind the microphone, I can't hear you.
I
Sorry.
do apologize.
Thank you.
So what the GCB, you would have seen in their comments, say is relate, and which I'm raising with you, the Scalabrini, you have listed it.
Yes.
Scalabrini and then PEPCO, and Lambertus van Velach as matters that, as application, leave to appeal or appeals that were upheld, right?
Yeah.
Your judgments were
Yeah.
upheld, you say. Now, the GCB says about Scalabrini that you say in paragraph 16.1 that you refuse leave to appeal in the matter. And therefore, it's not clear when you say your judgment was upheld on appeal if you did refuse leave to appeal. That's about Scalabrini. If you can just keep that in mind, let me give you the others.
Yeah.
And then with PEPCO, with the PEPCO matter, they say you granted leave to appeal and the SCA struck the matter from the roll. And then you list it as a matter, as a judgment that was upheld on appeal. And then the Lambertus van Velach matter, they have not been able to find a judgment on appeal. Now, if left without comment from you, it may create the impression that you might have listed, you must have stated this as upheld judgment when in fact they were not. Perhaps you want to say something about them?
No. The Scalabrini matter, there was an application for leave to appeal in front of me and I refused it. So then they must go to the appeal court, they must do something else. They haven't done it. So they asked for leave to appeal and it was refused. So it's properly there, an application where leave to appeal was refused and the matter was not overturned. The other matters, if I refuse leave and they go to the SCA, they petition the SCA for leave to appeal, and then they don't grant it, the SCA is not going to write a judgment on that. Every Tuesday you get your petitions. Those are judgments where the High Court refused leave. They then petition the SCA for leave, and then it's refused. That is properly a leave to appeal refuse. With respect.
All right. Yeah, all right. I'm not sure I understand how those two amount to your judgments being upheld. I mean, if you refuse leave to appeal, maybe let's go back to Scalabrini. You refused leave to appeal, as I understand.
Yeah.
I'm not understanding from your answer whether are you saying they then petitioned the
And then-
SCA and they were refused leave?
Then the SCA refused, which means they upheld my judgment.
I see. And then with PEPCO,
It's the
the
same
matter was
thing.
struck from the roll.
Um,
Why
but
do
they-
you say that is well, the GCP says that matter was
I
struck
don't know.
from the roll?
Well, they petition, matters get struck from the roll because they're late for various reasons, but they don't hear the appeal.
Yes, but you
Then the
consider,
appeal's upheld. You must remember very often parties bring condemnation applications, and depending on the merits of the matter, they do or don't get leave to appeal or condemnation.
okay. Thank you, Chief Justice.
Thank you, Commissioner Barroy.
CJ, may
Commissioner
I just
King?
follow up? I need to understand your answer, please, Ms. Bartman. On the Scalabrini matter that's just been debated with you, as I understand it, there was a judgment ultimately that gave relief by the Constitutional Court.
Yes, that was in Part B.
Oh, I see.
Yeah.
Okay, thank you. That does explain it.
Yeah, okay.
Are you satisfied, Commissioner King? All right. Was your hand up, Commissioner Notjes? Oh. Commissioner Trolley.
Thank you, Chairperson. Judge Bartman,
Good morning.
I'm new to the panel. I'm a member of Parliament representing Parliament. You say you've appeared before the JSC on 4 occasions.
For this matter, in fact, 5 matters. The first time I was successful, then I was appointed to the High Court.
I admire your tenacity,
Thank you.
and I want to just ask of you whether you've done some introspection about unsuccessful interview processes previously, and what have you done to address what might have been, or what might have militated against you being successful in the past, unsuccessful in the past.
You have High Court judges, all very experienced, very capable judgments. You're not at loss for choice. In fact, you're spoiled for choice. And the fact that you choose one candidate means at the day that candidate has what you were looking for. It is no reflection on the other candidates.
Thank you.
Is that all from you, Commissioner Trolley?
Thank you.
Oh, okay. You may switch off your mic. Thanks. Commissioner Marumahai, do you have any questions for this candidate?
No, I have none, CJ.
Thank you. Oh, may I just find out from you how many judgments you've written in your 15 years on the bench? Just an estimate.
That's many.
100, 200.
Come very close to
You did
100.
not answer, so I need to get back to the interview. What I wanted to do was to just check whether you have not printed this yet, because I'm going to send you something that you should print.
Can't
All right.
hear you, Commissioner. Just repeat that. Oh, my goodness. Commissioner, on the virtual platform, we just overheard your private conversation. Carry on, Judge Bartman. You said close to 100.
That should be close to 100, yeah.
Reported ones, just the rough estimate.
Reported ones are 3.
Okay. All right. Commissioner Nonkonyan.
Thank you, CJ. Good afternoon, Judge Batman. Thank you very
Good
much
afternoon, Commissioner.
for your presentation and for availing yourself. I'm just curious to know, in your illustrious career, whether you have had an opportunity to deal with issues. Thank you. Whether in your illustrious career you have been able to deal with issues pertaining to Khoisan and traditional leadership matters, traditional rather community matters, or not leadership.
One of the judgments that I've listed involves the Khoisan and the community, yes.
Was that it? All right.
That's all, Judge.
Commissioner Matolo Tlepu.
Thank you, Judge Batman. What I wanted to find out, the Deputy President of the Supreme Court actually indicated what that court needs. It was about tax, it was about intellectual property, and I don't remember the one, but I just heard you saying that you have done tax. But I think, how much did you do? I think that will satisfy me. How much did you do of what that court needs?
Of tax matters, I've done a lot of tax matters.
And intellectual property, that's what I heard.
Intellectual property matters I've actually written judgments on it, yes. You must understand that I'm in the Western Cape. We deal with these type matters really routinely. Even in our motion courts, you will have a matter that you must, on an urgent basis, deal with. Must certainly have dealt with them, yes.
And I imagine that that list would include shipping law matters.
Yes, it
coming
is.
from Cape Town.
Yeah.
Okay. It does not appear that there are any more questions for you, Judge Batman. Let me just join Commissioner Trolip in commending you for your tenacity and thank you for coming back time and time again to present yourself to this body. And I just want to assure you, I happen to have sat with you in a number of matters at the SA, so I know what you're capable of. I don't want you to take your previous failures before this body as an indication that you are not a good judge. So unless there's anything you want to ask us, you are excused.
Okay. Can I thank you, Chief Justice? I just want to bring something to the Commissioner's attention. The South African chapter of the International Association of Women Judges wrote a recommendation for me. It's dated the 2nd of September. When I received it, I saw that in paragraph 1, they referred to me having received a BA instead of a BURS. And in paragraph 2, actually the sentences 2 and 3 should be deleted. That's not reference to me. I contacted them and we resolved that I would ask the commissioners on paragraph 2 to delete the second and third sentence, and on paragraph 1, it's BURIS instead of BA. I think it's fair that you have just not leave it like that. It is wrong. Thank you. Chief Justice, that is all. Thank you very much.
Thank you. Thank you very much, Judge Bergman. You're excused.
May I be excused? Thank you, Commissioner.
Good day, Judge Chetty.
Good day, Chief Justice.
How are you?
Very well, thank you.
Good. Are you comfortable?
Yes, I am. Thank you.
All right. You hold 3 law degrees, BA Law and LLB from the University of Durban, Westville,
Yes.
and a master's from New York University on a Fulbright scholarship.
Yes.
Right. And what was your subject of specialty for your LLM?
I did work in labor law and in international human rights law in general.
Yeah. Then you started your legal career at the sidebar. You did your articles, then became an attorney.
Yes.
And you practiced as an attorney for about 25 years?
26, I
26?
think. Yes.
With the LRC, Legal Resources Center?
I was at the Legal Resources Center for just about 24 years and a bit.
Both in Joburg and Durban?
First in Johannesburg and most of my time in Durban.
All right. When were you appointed as a judge?
June or 31st May 2014. I think.
So it's been 10 years.
Yes.
What kind of work did you do as an attorney? What did your practice?
Well, I think during the time that I was in Johannesburg, from about 1990 to 1994, it was mainly claims against the police, matters of police brutality. But I also did a significant amount of work in employment discrimination work, as well as my work in respect of AIDS litigation. That was one of the main focuses at that time. And we spent a lot of time breaking new ground in terms of ensuring assistance or that people's rights were protected. Those people living with AIDS, their rights were protected. And we litigated quite frequently in that regard. One of the decisions that I reflected in my curriculum vitae is one of the early decisions of the right to healthcare for people with HIV and AIDS.
All right. You are based in the KwaZulu-Natal division of the High Court.
That's correct.
The whole of your
Yes.
your period of service as a judge.
Yes.
What legal areas of the law have you been exposed to in that division, and what kind of judgments have you written?
Well, I've been exposed to matters of customs and excise, issues of forfeiture of counterfeit goods by SARS, administrative law, education law, municipal law, elections, more recently patents, intellectual property, insolvency, business rescue. Those were areas that I was relatively unfamiliar with by virtue of my practice. But I managed to navigate my way through them, and some of the reported decisions reflect those areas of law. But I've done work in areas of planning law, contractual law, family law, a wide range of areas.
Maritime law matters part of the package?
I've had a few. Often they come up as urgent applications,
Yes.
sometimes so often over the weekends or late at night for the arrest of ships. And more recently, I sat as part of a full court to hear a matter concerning an associated vessel, but the matter had, the court took a decision to adjourn the matter because the SCA had already heard an appeal based on the same facts and in relation to the same vessel. And that was, I think, in relation to the Endeavour. And the court delivered its judgment on an associated, on what it considered to be an associated vessel.
You have acted at the SCA.
Yes, I have.
When and for how long?
Chief Justice, I think you invited me to the SCA to act for the first time, but
You were not available
unfortunately,
then.
no, my arrival coincided with your departure
Yeah.
to the Constitutional Court. But I've been there for 3 terms.
Did you get an opportunity to write judgments for the Supreme Court of Appeal?
Yes, I indicated
You
in
did
my
list
CV that I wrote 6 judgments, of which 1 I co-wrote, and in total, I think 3 of those were reported.
How many judgments would you say you have written in the High Court? It doesn't have to be an exact number.
I've never kept count, but the reported judgments, including, I think my reported judgments in the High Court are 20 so far.
All right, that's a fair number. Do you have any reserved judgments?
I've got 1 from
Reserved
the
from
last
when?
term.
Just from the last term, no, that doesn't count.
Yes, or from, I
Yet.
think it was in the latter part of August, that would be handed down shortly.
All right. You mentioned a few health issues in your application form, but you say they're under control. They don't affect
No,
the execution of your judicial duties.
no, they don't. I think I've taken up cycling. I've done about 11,500 Ks in the last 3 years. So
That's impressive. Okay. I see that you've done quite a few other things apart from your judicial career. You were, oh well, this is part of that. You were an arbitrator and mediator with IMSA back then.
yes,
And then you worked with the Development Facilitation Appeals Tribunal for a spell. What did you do there?
I joined or was appointed to the Town Planning Appeal Board and to the Development Facilitation Tribunal. And essentially it dealt with appeals from the municipalities in respect of planning decisions. And I was, after I think a period of 8 years serving on the Town Planning Board, I was elevated to the position of the chairman. And it entailed writing decisions primarily on administrative law issues in relation to planning infringements.
You also worked with the Foundation for Human Rights.
Yes, I serve on the advisory board as I'm also I think it's called a patron or member of the advisory board of the Legal Resources Trust.
Yeah. All right. No, thank you very much, Judge Chetty. I will hand over to Deputy President Zondi, who represents the Supreme Court of Appeal, to put questions, if any, that he may have for you.
Thank you, Chief Justice. Good afternoon, Judge Shetty.
Good afternoon, Deputy President.
I see that you have written quite a lot and on various aspects of the law. As you are well aware that at the CA, we have had a number of people either retiring or going to the Constitutional Court, and which has impacted the ability of our court to deal with issues such as company laws, intellectual property, and tax matters. I see that you have done some of, in the cases that we have mentioned in your pack, you also included cases on tax. Is it VAT? There's a case that dealt with VAT.
I'm sorry, I didn't quite hear that, Deputy President.
You're
The
right.
last part.
You, in one of the cases that you mentioned in your pack is the case that had to do with VAT, is that correct?
I'm sorry, just the last part of your question escaped me, Deputy President.
Okay. Can I just refer you to page 14 of the pack of the case that you indicated at paragraph 8?
Yes.
Yes, it's a case that had to do with VAT fraud, VAT fraud.
Yes, that's correct.
All right. Now, what about your exposure in intellectual property?
Well, I haven't had too much of exposure, save for more recently, where I've had to delve into issues of intellectual property and trademark, and I've been able to navigate my way around that.
Yeah, I must mention that you have dealt with shipping law as well. There was one case on which I sat, which was coming from your division. It's a case that had to do with an associated ship.
Yes. And I think there was another case that we sat on together concerning the termination or cancellation of a charter party agreement.
Right. I see that you, in your acting stance, page 19A, you acted at the SCA, well, paragraph 1 of the letter there, 19A.
Sorry, just 1 minute, please, Deputy President. You said 19.
Yes, 19A, paginated bundle.
Yes, I've got that.
Yes. That was the first stint in 2022 was, it would have been August to September sittings. That is the long term.
Yes.
And then the other terms are just short term. The November term is a short term. We start from the 1st of November, that is sitting.
Yes.
1st of November until the 30th of November. So basically you had how many terms? About 5 terms. Sorry, about 3 terms.
Three terms, yes.
One long term.
One long
and
2 short, yes.
Because, I mean, it's one of the concerns our colleagues have raised that maybe you haven't acted enough, but judging from the number of judgments that we have written, it does seem to me that that would be an impediment to your ability to contribute to the SCA, because I can say that you do apply yourself when you write judgments. Your judgments are well reasoned.
Thank you.
Thank you, CJ.
Thank you, TP Zondi. Commissioners, do you have questions for Commissioner Lekhanyan?
CJ, thank you so much. Good afternoon, Judge Chetty. I see.
Good afternoon.
Here on your CV, there is a strong motivation that you devoted almost the entirety of your life to the service of the poor, the less fortunate, and the historically marginalized, and your deep respect for fundamental human rights. I do not want to ask you a question. I just want you to elaborate on that aspect, your experience on the access to justice by that vulnerable section of society, and how the South African law in the new democratic order has served such section. Thank you.
Thank you, Commissioner. I decided more or less at the time when I was studying abroad that I wanted to pursue a career in public interest law. My first foray into that area was in respect of labor work, which in some ways is a microcosm of larger societal issues. You have issues of, particularly of discrimination, unfairness, and that gave me the springboard to move on to other areas of work. I've always seen my early career at university, and even before that, as a stepping stone to do something useful, to contribute to make our society better. And for that reason, I adopted a view that I would spend, if I didn't get appointed to the bench, I would have spent my entire legal career doing public interest work. That's who I am, and I think I would bring that experience to an appellate court or any court that I sit in. Insofar as I think the second part of your question is whether the plight of poor and vulnerable people has improved in our society, if I understood correctly, Commissioner?
If I may come in, Chief Justice, the perception is pervasive in society that South African law serves the rich more than the poor. So I got very impressed when I see the devotion that you have given to servicing this section of our society. And I thought you would be able to elaborate.
Yes. So
the extent to which, in your observation or your experiences, the law has been accessible. I mean, the poor have been able to access the law and how that has served them.
Yes. I think from a perspective on the bench, you still see vast degrees of inequality, but I think it's up to the judicial officers to be alert to inequalities, particularly in representation of poor and marginalized groups, and to be true to the objectives of our Constitution, to make it possible for marginalized groups to have their voices heard in court. And there are various ways that you can do that by ensuring that their matters are adjourned, or to ensure that they have adequate representation. But even apart from that, particularly when it comes to issues of evictions, judicial officers shouldn't approach it purely in a mechanical fashion, but should take into account all relevant circumstances. And if you find that there is no option but to grant an eviction order, you still have a latitude to determine, well, what would be an appropriate period of time for the eviction order to take effect. And it is in that regard that judicial officers who are faithful to the constitutional objectives can ensure that even people who are marginalized or poor, the brunt of our laws can be somehow ameliorated. I hope I've answered some of your questions.
Thank you, Chief Justice. Thank you so much.
Commissioner,
No, thank you very much, Chief Justice. Good afternoon, Judge Shetty.
Good afternoon.
You have just recently handed down a judgment between the African National Congress vis-a-vis the Umkhonto weSizwe Party. Now, my question with regards to that, how do you ensure that ensure your judicial independence and impartiality in such high-profile cases?
Well, I think I'm a fair person. I determine any matter, whether it be high profile or not, based on the facts before me, based on the law before me. I don't succumb to any external pressure. I simply concentrate on the issues and on the law.
Thanks for the response. My second question would then be with regards to your professional experience, which covers a wide range of legal fields, including the constitutional administration and commercial law. How does this diverse background contribute to your suitability for the position on the Supreme Court of Appeal?
Thank you. I think it's precisely that. A diverse range of cases that I've dealt with. I would be able to bring different perspective to some of the thinking, but also I think mainly my almost 25 years as a public interest lawyer, I'd be able to bring that unique perspective to the court.
No, thank you very much for the response. Thanks, CJ.
Commissioner Muyimang.
Thank you, Chief Justice. Thank you, Chief Justice. Good afternoon, Judge Chetty.
Good afternoon, Commissioner.
Yes, I want to take you back to the ANC versus MK, the judgment. But my angle is different. There are two parts. Of course, the first one relates to where you said that the ANC chose the wrong forum to assert its rights. I don't have a problem with that. Where I want to get your comments, is your observation on the merits. You say that apart from the distinctive green background on observation, the listed mark of the ANC and that used by MK are similar. Although a careful eye will notice a difference. The question that I want to ask from yourself is what is your understanding of the first user principles, which comes from the common law, which in a sense suggests that even if you do not register your trademark, you have the cause of action against an alleged infringer on the grounds of passing off. I'm raising this point because the claim was also brought in terms of contravention of section 34(1)(a) of the Trademark Act. Just on the basis of the first user principle, what is your appreciation of that? Don't you think that the first user principle, in a sense, if that was applied by the esteemed judge, a different conclusion would have been raised?
Well,
thank you, Chief Justice.
yes. Commissioner, I'll have to respectfully say that I'd have to possibly sidestep it on the basis that I've granted leave to appeal in the matter to the SCA. So I'm not sure whether I'd be permitted to express my view, because I've already indicated that another court might or would come to a different, or could come to a different conclusion on that aspect.
Thank you, Judge Chetty. Thank you, CJ.
Thank you.
Sorry,
can
I've
I
been
just,
asked by the CJ to manage the proceedings in that while she's just going out to make an urgent call.
The next Deputy President of the SCA, I just want to follow up.
Okay.
If you don't mind.
Sure.
Judge Shetty, I do think you should do justice to yourself by engaging with the discussion. You've granted leave, so it's out of your hands.
Yes.
I think the Commissioner might repeat his question. I mean, he's basically testing the reasoning you gave in the judgment. I think that's a fair question. I just don't want people to say that you avoided answering questions.
Thank you, Commissioner. Commissioner, if you'd be so kind to refer me to the particular paragraph that you wanted me to address you on of the judgment.
Thank you, Judge. In the judgment, you say that when dealing with the merits, apart from the distinctive green background on observation, the registered mark of the ANC and that used by the MKP are similar, although a careful eye will notice a difference at the height in which the spear is held by the warrior. You heard that that in itself no trademark resemblance to each other were so closely deceptive or confusion, or could cause confusion among voters, would not have led to that. Now the question that I'm asking is, based on the first user principle, which is a common law, on the basis that the passing off suggests that you cannot represent your good or your service. In this instance, the MKP continues to represent the MK as their product. So now, but my argument is that even if you do not register a trademark, the infringement based on the first user principles, informed by the fact that this logo, the MK, was used by the ANC since 1961. Had you used the first user principles, don't you think that you would have come to a different conclusion? Obviously, it hinges on your on your conceptualization of the intellectual property rights, passing off trademarks. Yes.
Yes, thank you, Commissioner. If I understand, you're referring to that section of the judgment from paragraph 70 onwards. Would I be correct?
That's correct, because that's where you express yourself on merits.
Yes.
So I'm saying that don't you think that had you applied the first user principle, you could have come to a different conclusion?
Possibly. I accept that. It wasn't argued on that basis, though. The contention by the applicants was that the mark had been used by the ANC for a number of years, and that the respondent, being the MK party, had no prior history of use of that mark, and therefore was seeking to essentially ride on the coattails of the ANC. But I accept the point that you raise.
No, thank you, Chief Justice. Thank you, Judge Shetty.
Minister?
Thank you very much, Chief Justice, and good afternoon, Judge Chetty.
Good afternoon.
I see you're
Good
trying
afternoon.
to locate the voice. No, just on your CV, the questionnaire actually, on number 6, it says, I'm not sure if you can locate it, please furnish chronological particulars of employment since leaving school or university.
Yes.
Can you locate that?
Yes.
Yes, it's section 1 under personal.
Yes.
Yes.
I see that.
Yep. You have filled the KZN Town Planning Appeals Board together with the tribunal. The
Yes.
position held, but with no period.
Oh, I see.
I'm
Yes.
not sure whether it's an omission, and maybe you can fill us in.
I held those positions during the time that I worked at the LRC. So they were purely additional positions that I had held, and that would have been from the period 1994 to, I think, 2014, around there. But I looked at question 6 again, and perhaps I interpreted it in a rather strict sense and just went to the time that I started articles. But I'd obviously worked during the time that I was at university, but those were casual jobs along the way. But coming back to your question, Minister, the positions that I held at the Town Planning Appeal Board and the Development Appeal Board were positions that I held during my time at the LRC, and with the consent of the national directors during those times.
So was it the appeals board and the board for the municipality or the province?
Oh, no. It was for the, it fell under the provincial government, under the, I think under traditional affairs, if I remember. That's where the town planning component resided.
Okay. And secondly, the widespread, maybe we may want to find details there. I'm not very certain of, because of the time periods in the 90s and I follow, and I'm sorry for taking you back. I thought I was moving forward with my last question. The town, you say the at the time you were at the LLC, and it looks like you started in 1990
Yes.
at the LLC. Now I'm not sure whether the same was relatively at the same time, because then it can tell us the functions of what exactly.
Oh, no. Yes, thank you, Minister. If I could clarify that. During the period 1990 to 95, so I was in Johannesburg at the LRC in Johannesburg. I moved to Durban in 1995, and it's only later during that period of 1995 to 2014 that I'd served in my capacity as a member first and later as the chairperson of the Town Planning Appeal Board. But that would have been in KwaZulu-Natal.
Okay, it's all right, Chair, let me get off it, because it would have been then different bodies. I think that's the point that I'm trying to raise. It would have been prior the tribunal system, if my understanding is correct, earlier on, if it dates back before the 1990s. There have been the widespread concern in the recent times about what is termed judicial overreach. As a judge of the SCA, how are you going to maintain the balance between polycentric matters, which are in the domain of the executive, and the need for the judiciary to discharge its responsibilities within the parameters of the Constitution? I think you touched on it a little bit, but an expansion could be of help.
Well, I think both in the SCA and in the high courts, judges are mindful, or should always be mindful, not to tread on the terrain of the other arms of state. And I think that by and large, our courts have adhered to that, and that there is a mutual respect for the roles of the respective arms of state.
Thank you, Minister. JP Mlambo.
Thank you, Chief Justice. Good afternoon, Judge Chetty.
Good afternoon, JB.
You are applying for permanent appointment to an appellate court. Can you tell us about your exposure in full court appeals, that is in presiding and scribing full court judgments in the division,
yes.
KZN division?
Yes. Thank you, JB. I've presided in full court appeals in respect of more recently in criminal matters, but I've scribed in full court appeals from relatively early on,
yes.
After my appointment. One of the decisions that I've included, which was reported, is a matter of Jeria versus Outshortens, where I scribed for full court. And I've done so on other occasions. I can't remember the exact matters, but that's the only full court matter which is reported.
Yes. and then you've sat in the SCA, but have you not had other appellate exposure, say sitting in the LAC or so?
No, I've not sat in the Labour Appeal Court.
I see. And then in the Supreme Court of Appeal, have you scribed any matters that involved a constitutional issue?
There was one matter that I think, which was subsequently I learned went to the Constitutional Court concerning it was a judicial officer or a military judge who was seeking to challenge certain aspects of the military code. The SCA, I co-wrote that decision, or a minor part of that decision.
Yes.
And that has gone on appeal. But essentially, the military judge was seeking to have or to be treated in much the same way as a judicial officer would. But that's the only matter, Judge President, which I think I recall that dealt with some constitutional angles.
Okay. No, thank you. Thank you, CJ.
Thank you, JP. Commissioner Gotsal?
Thank you, CJ. Good afternoon, Judge. A concern was raised with the time frame for delivering judgments in the High Court. Your track record in the SCA is all very good. Can you just comment on the lengthy periods for delivering judgments in the High Court? I can give you some more information if you wish.
Commissioner, are you referring to the comment by the
General Counsel of the Bar?
Yes. By and large, I try and get my judgments out fairly quickly within the allocated time frame. Some matters are obviously more complex than others. And I've never had any occasion where parties have had to write to the Judge President to inquire of lateness. And the practice that I do follow is that if I were to take further time in a matter, I would write in advance to the parties to give them an anticipated date when I would be able to deliver.
So the 4 judgments that was delivered between 5 and 6 months, would you in those cases have written to the parties to say that you need
I would have in most of these cases. I can't remember the specifics, but I would have always done so. If there was an impediment that came into me delivering it within the general period of 3 months, I would have indicated to them. Thank you.
Any more questions, commissioners?
It's me this side, Chief Justice.
Commissioner again?
Is it my turn, Chief Justice?
Yes.
Well, thank you, Chief Justice. Good afternoon, Judge Chetty.
Good afternoon, Commissioner.
You struck me as a diligent and hardworking judge, given the fact that you were able to deliver your judgment, most of your judgment, timeously. What do you attribute that to? I see Saula says that you have a full grasp of the law.
Yes, I wasn't quite sure what to make of it.
Saula made a recommendation based on 2 sentences. They said that you were appointed in 2014 and you have full grasp of the law. And I want to agree with that. But then there is a judgment that you penned at the SCA. I don't know if you remember this judgment.
Yes, I'm aware of it. It was a matter that concerned a personal injury claim on behalf of a minor child.
Yes, but that's
Yes.
not the judgment I want to ask you about. The one that I want to ask you about is the one of Mhlonlo local municipality and others versus Cini Kaya Ngakula. It was an appeal from the Eastern Cape.
Yes.
Do you remember that matter? I must commend you on it because it is a well-written and beautiful judgment, more especially because it deals with the issue of concurrent jurisdiction between the Labour Court and the High Court, as well as the exclusive jurisdiction of the court. And I note that you did not make it reportable when such issues are everyday issues in the High Court.
I think the practice at the SCA is that we, guided by the presiding judge as to whether a matter should be marked reportable or not, but you're correct, it wasn't marked reportable, but it was subsequently reported.
Yes, because it is really a conundrum in the High Court. But given the time that you spent in the SCA, where you have had an overview of the judgments that come from various divisions, would you be available to provide training for judges in the lower divisions, in the High Court divisions to be precise?
If I'm called upon, I would certainly avail myself.
Thank you.
Thank you, Commissioner Mangena.
Could I follow up, Chief Justice?
Yes, Commissioner Jozitube.
Thank you, Chief Justice. Judge Chetty, I just want to go back to an earlier question that has been asked, which is related to the discussion you've just had now with Commissioner Mangan. You said that you have not delivered a judgment where constitutional issues arise in the SCA. Did I get that correctly?
Yes.
Well, I mean, because you gave the judgment in Siangena, where Section 33 of the Constitution applies, Section 172 of the Constitution applies. You also gave this judgment that you are discussing now with Commissioner Mangan, in which you had to apply the Baloy judgment of the Constitutional Court about who has the jurisdiction to decide labor cases, which is also a constitutional issue. So I just wonder whether, I suppose whenever we say constitutional, sometimes I get confused, what do people mean? Because the judgment of Chaskalson, CJ in Kamisha said that the starting point is the Constitution. And then everything else is subservient to it. So it's just to get clarity there. But what do you mean when you say these are not constitutional issues, when the judgment itself cites the Constitution and applies it?
Yes. Thank you, Commissioner. I suppose the ambivalence lies in exactly how you define what is a constitutional matter, and you're quite correct. Siangena dealt with the issue of relief specifically under Section 172 1B, and where we upheld the relief that was set out by the High Court, and we said that there was no basis to interfere with it because it was the exercise of a true discretion. But perhaps maybe I misinterpreted the question, and I suppose for that matter, in the SCA, I also scribed, I think it was 1 or 2 matters that dealt with the issue of prescription. And there too, one has to consider the underlying constitutional principles in terms of whether somebody who is relatively unsophisticated, who has who lives in a far-flung rural area, no access to advice, in respect of whom prescription periods can be held strictly applicable. So I take the point.
Yes, I mean, it does go beyond the characterization of a specific issue about really what do we mean when we say the Constitution is supreme? And to what extent is a court like the Supreme Court of Appeal committed to starting with the Constitution when it's construing our law? So that we don't only ask the Constitutional Court to deal with the Constitution, but we put the foundation of our system in the hands of the Constitution. And so when someone like you is, especially who's had an incredible record of 26 years working for poor people, is going to the SCA, we then look upon you that you will now finally translate this constitution into reality. So I get concerned when you are ambivalent, as you say, because I depend on you not to be ambivalent.
No, my point about ambivalence was the question, not about the constitutional interpretations. But, they've been also, I accept your point that you raise in terms of the Constitution obviously being the starting point. But it's difficult to answer a question where almost every judgment you've written touches on aspects of the Constitution. And the other answer that I could have given, well, every matter that I would have written would have been a constitutional matter.
Thank you, Judge Chetty. Commissioner Marumwangai? Are you there, Professor?
Yes, I am. Can you hear me?
Are you ready?
Can you hear me, CJ?
Are you ready to pose questions to the candidate?
Yes, I am. Can you hear me?
Yes, we can.
Oh, thank you very much. Good day, Judge Chetty.
Good day, Commissioner.
Yes, I wanted to raise the issue of constitutionalism in as far as judgments are concerned, but I think that ground has been covered. Can I take you back to the discussion that you had with Commissioner Muimang with regards to the MKANC intellectual property issue judgment?
Yes.
I'm not really sure if you can be really criticized in that judgment. I had the benefit of actually watching the proceedings. And in paragraph 2 of that judgment, you lay out what exactly the judgment is about. And in paragraphs 71, 73, and 74, you actually deal with the issue of the common law remedy of unlawful competition, which is basically a dealing. I just want to ask this. In this particular judgment, were you concerned with the issue of one party claiming an infringement over a particular goodwill based on something that was in practice at the time and being used at the time? Or was it something that was done historically? In other words, when you are going to the elections, you have the ANC with its own logo that they are competing with. But now you are having MK on the other side coming with something that has historical value to the ANC. Under those circumstances, can we really say that the common law remedy of passing of unlawful competition has any role to play?
Thank you. I'm not sure if I have to go back and visit or revisit my judgment. I've said everything that I needed to, and I'm not sure. I'm looking at the section that's been raised with me, under paragraphs 40 onwards, or 70 onwards. But as I indicated earlier, the argument raised on behalf of the ANC was essentially that the MK Party were exploiting its history by adopting a logo similar to its, and that where in circumstances they had no equivalent history to fall back on. And that was, as I understood it at the time, when it was argued, the issue of the infringement and the common law passing off argument.
No, you are quite right. Your approach is quite right. That was the third ground that the ANC relied on. And in paragraph 71, 72, 73, 74, you actually disposed it quite correctly. So the issue of first user in these circumstances was not applicable. And you are quite right in your approach. I'm not sure if you can validly be criticized of your approach. Thank you very much, CJ.
Thank you.
Thank you, Prof. Do you still want to say something, just Chetty?
No, Chief Justice, other than to say that I believe that my varied experience in the High Court, together with my experience as a public interest litigator, my experience at the SCA, having worked with colleagues, having benefited from the interchange and the engagement, the intellectual rigor that court demands, the preciseness, the brevity, and the need to speak clearly through one's judgments is something that I believe I would be able to make a positive contribution in. And in that respect, I would also bring my my diverse life experience to that position. But that's all that I have to say. The rest is in the hands of the Commission.
Thank you very much, Judge Chetty.
Thank you very much,
And
Chief
for
Justice.
making yourself available.
Thank you.
I'm thanking you for what you just said and for making yourself available for the interview.
Thank you.
You're excused.
Thank you.
Commissioners, our lunch is ready at the restaurant just around the corner when you leave this room. We set ourselves 45 minutes, so I expect that we will stick to our undertaking to ourselves. So we come back at 2 sharp. The candidate will be sitting there waiting to be interviewed at 2. Enjoy your lunch.
Can we leave our computers here?
Good afternoon, Judge Copin.
Good afternoon, Chief Justice. And
How
good
are
afternoon.
you?
I'm fine.
Good, good. I just wanted to get something out of the way for me right at the outset.
Yes.
It's a nasty question, but a necessary one. We live in South Africa, and this is an issue for us. And it's the issue of your race. You've described yourself as colored in your form, which is what should guide us. But then one of the professional bodies have written in and said you're a white male. And so will you just assist? Are you a white male?
Well, I don't know which white male would be born in Kliptown, Soweto, and attend school in North Wissel Secondary School, which is also in Soweto right now. But in any event, to put the record straight, I've got nothing against white males.
Of course.
Whiteness, they can also make a valuable contribution. But yeah, as far as my blackness is concerned, I've always considered myself black. Always considered myself that.
No.
I need not tell you that I'm biracial, not myself. Both my parents are biracial. So I share African black relatives and supposedly white relatives that I never got to know. But my life was really lived more in black society. Even though I was colored, I mean, if you look at Kliptown, all these places are placed very strategically. It was for us to share our family, to be close as a family, despite the fact that we were categorized as colored and African black. But my experience has always been black, and I've never had privileges. I'm from a rather poor background, and I've experienced all the sufferings, poverty, lack of running water, bucket toilets, long drop systems, poor schools. I've attended schools. Throughout my schooling career, I was in asbestos classes, bad education, lack of teachers. And you'll see that I even became a teacher soon after I passed matric because there were no teachers to serve us. Yes.
Yeah.
So my experience of life has been rather a very interesting one. And I can relate to all the things that we encounter even up to this day. As far as poverty is concerned, the need to change. And I was just privileged because I managed through hard work and sheer dint of luck, I think, to make it through all of this and get to university and eventually go straight from university to the bar because I couldn't secure articles because I was either not black enough or not white enough. And I managed to get to university, which I finished in time, and I knew that I now had to go and make a living at the bar. It wasn't an easy thing, but I was grateful to black practitioners that helped me through my first years. And very soon after that, maybe by my fifth, sixth year, or at the time, I should rather say at the time when things changed and we started getting state work, my practice changed dramatically. But by then I had built up quite a lot of experience by taking all kinds of work, including criminal work. Whatever came along, I took. And so I had a wide experience of all kinds of work, civil work, magistrates court work, labor work. And then I managed to get into state work. I did a lot of work for the government, for the state, mainly in the fields of health and then foreign affairs. Yes. So by the time, and then obviously a lot of work for the NPA, the old NPA with the Scorpions. I was involved in the commissions of inquiry, Campepe Commission, Heifer Commission. My first baptism of fire in the Constitutional Court was, of course, one of the biggest cases at the time, the pharmaceutical case, where I appeared on my own, representing the state president. And yes, so I had a privilege of representing the state in rather very important cases concerning the accessibility of medicines to people. And in the course of that, I acquired lots of other skills because you'll remember people never wanted to advise the government because they took an opposite view to the government when it came to things like parallel importation and whatever. And I had to learn things like patent law, copyright. I picked up a lot of experience from those cases. And as I say, at the height of my career, when I had taken silk and practiced for about 5 years, I decided, purely because I was now keen to know who are going to go to the bench to serve the people as judges. And I often used to look around, and then it occurred to me, what about you? And that's the reason why I then offered myself. I said, well, I'll go to the bench. And my family were not very happy with my decision because that meant taking a huge drop in my income. But in any event, I ended up there and I've never regretted it. It took some time getting used to being on the bench, but after about 7 years, you realize you're going to do nothing about the salary. You must adapt or die. But the work was one of the most satisfying things that I have done thus far. I am in my 15th year. I've already got my gratuity, which means taking into account my acting stints. I've done about 15. I'm going now for my 16th year. And I've also then acted in the Labour Appeal Court from about 2012. In 2014, I was active.
You started at the Labour Court?
No, I never started at the Labour Court. I started in the High Court.
No, but in your application form, you say you acted as a judge in the Labour
Court.
Court.
Oh, no, I acted there, yes.
And in the Small Claims Court as well.
From 1999, I acted in the High Court. Then consistently after that, I also acted in the Labour Court, alternatively in the High Court. And I was a small claims commissioner before even I started my acting stints in the courts.
Very important work, that. So you were at the bar for 25 years?
24, I think.
24?
24 before I went to the bench.
And if a quarter of that period as silk?
No, I think I was a silk for 5 years.
5 years.
Before I went to the
bench. Okay. Well, thanks for that lengthy background. You've actually covered a lot of the ground I would have covered with you anyway. Just an interesting feature. I see that you started acting as a judge exactly on the same day I started acting as a judge, but in another division on the southern tip of the country. So you and I share that in common on 26 July 1999.
Yeah, myself and Judge Dunstan Mlambo started on the same.
Oh, I didn't know that.
But he at that stage was obviously a judge in the Labour Court.
Yeah. How long have you acted at the SCA?
Well, the first time I acted there was, I think, 2016, 2017, which was for 2 terms. And then I've been acting there since the 1 December last year. And up to now, which has been extended.
So that's how many terms so far? 6 terms? Let's see. No.
Well, I was 2 terms I can't, I think that.
When did you start acting on this recent stint? In December?
It would be December, yes.
Oh, okay. So that's 3 terms over plus the 2. That's 5. Okay. Well, it's you've mentioned a number of the judgments you've written in your in all the codes, all these codes you've set. And from your narration, it is clear that you have wide experience in almost all, if not all, the facets of the law. Is there anything else you want to add to this profile?
Well, simply to say I'm not perfect, but I think I have the necessary skills and experience at this stage in my life. Because remember, I was a judge in the Labour Appeal Court. I was appointed there for 10 years. I completed my 10 years at the end of May of this year. And the only other place I could actually display and be of assistance with my appellate experience would be in the SCA.
Yeah, right. 10 years you spent at the Labour Appeal Court.
That is all.
Yeah, all right. No, thank you very much, Judge Kopin. I'll hand over to DP Zondi to carry on with your interrogation.
Thank you.
I'm joking.
All right, thank you very much, Chief Justice. Hi, good afternoon, Judge.
Good afternoon, Deputy President.
First of all, I just want to tell you that from the comments I received from the colleagues, everybody commented positively about you. So I don't have any negative comments to report to this body. As you are aware that the SA has lost a lot of experience through colleagues retiring, some of them appointed to the Constitutional Court, and that has resulted in the SAA suffering in certain aspects, such as tax, company law, and IP. I've just gone through your judgment, and there is no doubt in my mind that you do have sufficient experience in these areas where we have got a skill shortage. How have you found your acting appointment at SA? How have we treated you so far?
As I say, it's been a very good experience. I've enjoyed it, and it's been a very good experience thus far.
Have you had any situation where maybe you had dissented and the colleague did not take it kindly to you dissenting?
No, not in this round, no. Okay. Maybe in the previous round.
In the previous round?
Yes.
But this time around, none of them?
No.
Okay. All right, thank you, Chief Justice. My neighbor.
Good afternoon, Judge Coppin.
Afternoon, Judge President.
I just need to deal with your appellate judge exposure. You are in the Gauteng division. Can you tell us in how many full court appeals have you presided and you scribed?
Well, I can't remember how many I presided in. Scribed. I can't also remember, maybe 1 or 2. I can't remember exactly.
You can't remember, but is it the number of numerous occasions?
On numerous occasions, yes.
I see. And any comebacks in terms of those full court judgments being reversed?
No, I haven't had any of them reversed, no.
Right. And then you say you've been in the LAC for 10 years.
And I acted prior to that for about a period of 2 years. Yeah.
Right. So you have unquestionable appellate exposure.
That is so.
Appellate court exposure, if I may put it that way.
That is so.
I don't hear the answer.
As I say, that is so, but doesn't mean there's no room for new experience.
Yes, yes. And in the SCA, you acted for the first 2 terms, 2016, 2017, and now you've been there for how many terms now? 3 terms, 4 terms?
I think I've been there for 3 terms.
Yeah, because
the 4th term will be in November.
the president has approached me to extend your acting stint, in case you don't know. Should I take it that means your value add is seriously recognized in that court?
Well, I would assume so. If they
Thank you.
wanted to extend my term there. Yes.
Thank you. Thank you, Chief Justice.
Thank you, JP Mlambo. Commissioner Marumachai? Prof. Marumachai, are you there?
Yes, TJ, can you hear me? I was saying there are no questions from my side. Thank you.
Oh, thank you. Any questions for this candidate, commissioners? Commissioner Trollip?
Thank you, Chief Justice. Judge Coppin, I'd like to just follow up on the initial question that the Chief Justice put to you about your racial demographic.
Yes.
You told us about your life experience. What languages did you grow up speaking? And what languages do you use in your judicial practices?
Well, my father's grandfather was chief of the Mambai tribe. So they spoke a Mambai language, which is linked to the northern Sotho languages. But of course, they then, after losing their land, started speaking Siswati. My mother, his father is an Englishman. So my father also spoke English. He attended school in a school where the medium was Siperi, I think. But he could speak, at the end of his life, he spoke about 16 languages. That's my dad. My mother also has a Peri mother, so her mother tongue was Peri. Her mother then married a Swazi man after my mother was born. So their language then became Siswati. And when my parents got married, they spoke to each other in Siswati or English. So we were exposed to that. They actually didn't understand a word of Afrikaans. But when we had to move to this place, you see, I speak about North Osa Senior Secondary School. We had to move there because my granny, my father's mother, had to move to Joburg, and she could only live in a black area, which was in Diepkloof. So, I think, which was in Diepkloof. But the point is, my parents, which was in Diepkloof, so we were living in North Osa. My father didn't see any need for us to go to any schools other than the local schools. The local schools in North Osa were all Afrikaans medium schools. So that's where I went to both my primary and secondary schools were in Afrikaans medium. So as the children in our home, because we all went to this Afrikaans medium school, we spoke to each other either in English or Afrikaans, but my parents communicated to us either in Siswati or in English.
Thank you.
Was that your only question, Commissioner Trollip?
Yes, thanks, Chief Justice. Sorry, Chief Justice, I did ask, I said, what languages does the judge use in his judicial work?
I use English, or I've never written in Afrikaans, but I mean, I understand it. But I've really only used English.
Just one last question from me. You mentioned a health condition in your questionnaire. I take it it's under control.
That is under control, yes.
Okay. No, thank you very much. I don't see any further hands. Oh, we have one from the minister.
Thank you and good afternoon.
Good afternoon, Minister.
I just wanted to know, out of interest, I see in 18.4, as part of your experience and knowledge as a practitioner, on the questionnaire, you have also, lectured at SIJ, our college, our
Yes.
institute. What do you think we could, bring into action that could assist in the training of aspirant judges in a better way than we are doing now? Any views, any thoughts? I mean, there's no right or wrong answer, really.
As I say, I mean, I was invited there. The first round, I think, by Judge Matopo, and the second one by Judge Mochapelo. And I mean, I think they handled it as best as they could. I was just asked to present on a particular topic. As I say, I'm not sure of any shortfalls in the education. And yeah, what I encountered there was that the best was being done in the circumstances.
Thank you, Minister. Commissioner Moimang?
Thank you, Chief Justice. Good afternoon, Judge Copen.
Good afternoon, Commissioner.
This side.
Oh.
Thank you. Justice Copen, just on your pronouncement on two cases, the Mohale Alwais versus Muko Crow.
Yes.
I see that Professor Badenhorst expresses a good news on your grasp on the mining law, particularly on your interpretation of Section 11(2) of the Minerals and Petroleum Resources Act. Would you mind just to share with us, because they say they praise you for good law, as far as it was held that the ministerial consent is required if controlling interest is in a company moves away. You can just share with us the reasoning behind that. Thank you.
Sorry, I'm not understanding the question, Commissioner. If you say share, do you want me to discuss the judgment?
Yeah, your appreciation of Section 11(2) of the Minerals Act.
Oh, okay.
Thank you.
No, it's to do with control, that the moment there's a control in a company such as that you would have ministerial consent being required. And the whole purpose of the ministerial consent, I assume, was to vet the candidates, because obviously it's got to do with a wider objective, the BEE objective. So once the ownership within a company changes, or the control of a company changes, that's what I found, then the minister must be involved in the process, and the minister would have to consent to that. That's really the nutshell of it. So that you'd have people, for example, that will establish a company, get the necessary approval to establish it, and in the meantime, the whole inside of the company changes. Controls change. So people could bypass the PE objectives by doing something like that.
Thank you, Justice Copen. Thank you, CJ.
Commissioner Trollip, did you have a follow-up question?
Yes, please, Chief Justice. Judge Kun, did you dismiss
Judge
former...
Coppin. I'm Judge
Sorry, Coppin.
Yeah.
Sorry. Did you dismiss Vodacom employee Nkosana Makate's case against Vodacom?
Yes.
Costs?
Yes.
Could you tell us what your thoughts are on the latest developments?
I don't know whether it's a problem. I mean, this thing is in the news. As I was asked about this.
Sorry, before you answer the question, Judge Coppin, are you asking for the latest developments with the case?
I say that case is before the courts right now.
No, I'm asking the commissioner.
Yes.
Are you asking him to comment on the current status of the Makate?
No, not necessarily, Chief Justice. I'm interested.
Just repeat the question.
I'm interested that the judge had dismissed his original claim, and now there's a matter before the courts where the claim is significant. And I asked him if he wants to share any thoughts on that.
I'm very uncomfortable with that question. That case is pending before the Constitutional Court as we speak.
I withdraw.
And he may, who knows where he might stray in trying to answer your question. Judge Coppin, thank you very much for making yourself available for the interview.
Thank you.
Unless there's anything you want to ask us or raise with us, you're excused.
No, thank you very much.
Thank you. Oh, is it on? Good afternoon, Judge Kun.
Good afternoon, Chief Justice, and good afternoon to the commissioners.
Are you comfortable?
I am, thank you.
Thank you. Well, you've been here before, so you are familiar with the terrain.
Thank you.
Good. You hold a BCom and LLB cum laude
That's correct, yes.
degrees and a diploma in arbitration.
Correct?
Your degrees you obtained from the University of Natal.
That's correct.
Okay. You started out as an attorney.
That's correct, yes.
How long were you at the sidebar?
I did the articles for 2 years, and then I practiced as a professional assistant at the firm that I did articles at, which requested me to stay on, and that was for 1987, and then 1988 I started pupillage at the bar.
And you remained at the bar until your elevation to the bench?
That is correct. I practiced as a junior until 1997, then was fortunate to have silk conferred on me, and I practiced as a senior counsel for 8 years until I was elevated to the bench in 1 November 2006.
In the KwaZulu-Natal division of the High Court?
That is correct, yes.
So you've been a judge since 2006?
Yes, from 1 November 2006.
And you have had occasion to act at the Supreme Court of Appeal on a number of occasions?
Yes, I have. I started in 2015 with one particular appeal. I was appointed for 2.5 months for that appeal.
Was that the potato board matter?
That's the potato co-op matter.
Yeah.
With, I think it was 88,000 pages. And I did that part and then returned because of other commitments back to KZN and then back to the SCA from, I think it was 2019.
Okay. I'm not going to ask you about the judgments you have written. You've appeared before this body before, and we know that you are highly regarded as a seasoned judge who has experience in all the aspects of the law, if that is possible.
Thank you.
I just want to comment that something struck me about the comments that have been written by some of the people who commented on your candidature. And it's about your character. You are described, well, the one I found the most touching is where I think it's one of your nominators described you as a fundamentally good human being. And I thought, my goodness, that's the best compliment any human being can ever be paid.
Thank you.
Yeah. You have mentioned certain health issues you suffer from in your questionnaire.
Yes.
But then hastened to reassure us that they are no impediment to the execution of your judicial duties.
Yes. No, in 2010, I had what is commonly referred to as a single bypass procedure, but I have had no problems since then. And in fact, I walk extensively, doing Camino walks in excess of 120, 140 days and 7 days in Spain, locally in the Cape. And I have no problems with any health issues.
Yeah. You are super fit, in short.
I don't know about that, but
no one who can walk 100 kilometers without being super fit. Okay. All right, thank you. I will leave things here for now and ask Deputy President Zondi to put questions, any questions I might have for you, to you. DP Zondi.
Thank you, Chief Justice. Good afternoon, Judge Kuhn.
Good afternoon, Judge Zondi.
Okay. First of all, I just want to place on record that from the comments that I have received from the colleagues regarding the suitability, no concern was raised. So everybody was supportive of your candidature.
Thank you.
I see that you have been a judge since 2006, is that correct?
That is correct. On the 1st of November, I'll be a judge for 18 years.
Yes. And during that period, while you were at KZN, you had an opportunity to preside.
Yes, on numerous occasions.
Okay. So when it comes to presiding over the appeal cases, you do not have a problem?
No, I wouldn't have a problem. As with all courts, we've had a number of senior judges retiring at that level. So from a fairly early point, I was in the top 5 to 6 seniority-wise within that division. And as such, all or virtually all full bench appeals, 2 judges, I'm the senior presiding, and on full court appeals, the 3 judges, I am almost invariably the senior presiding.
I've got no doubt in my mind that you'll be able to assist the presider should you be appointed on a permanent basis at the SCA, and you'll be able to contribute.
Yes, I would certainly like to think I would, by virtue of my experience and particularly the appellate experience, because often perhaps less experienced colleagues don't always appreciate that an appeal is not a new or a re-hearing of the matter. You have to show that there's a misdirection in the judgment of the court or quo. So those kinds of appellate type nuances are important in any appellate court.
All right. Thank you very much, Chief Justice. I've got no further question to Judge Kuhn.
Commissioner,
Thank you very much, Chief Justice. Good afternoon, Judge Kun.
Good afternoon, Commissioner.
You have handled significant criminal cases, including the state vis-a-vis Timkulu, as well as the state vis-a-vis Gutier, which involved issues of sentencing and parole.
Yes.
How do you approach the balancing act between public safety, rehabilitation, and fairness to the accused in criminal sentencing? And do you also foresee any areas of criminal law where further development is needed at the appellate level?
I don't foresee anything in the immediate future. Sentencing is a very, very personal issue at one level, in the sense that one must never underestimate the benefit that a trial judge has, being steeped in the atmosphere of the case, as to what an appropriate sentence is. Having said that, at the same time, I'm not suggesting that one shouldn't interfere with a determination of a sentence that is made by a trial judge when it's inappropriate. But it's the normal triad of factors, obviously. One looks at the interests of society, one looks at the nature of the offense, and one looks at the personal circumstances of the accused. It's a balanced exercise. It's one that comes only with a lot of maturity and many, many years on the bench. It is not something that should be taken lightly. You would have, in the judgments that you referred to, the one in particular was a sentence that had been imposed, which came before me and a now retired judge of the SCA, Gorman, in respect of the accused had been convicted of sexual impropriety, sexual assault. And the sentence imposed by the trial court, this was a pastor who had abused a situation and a relationship of trust and interfered with a number of young ladies, girls, in fact, that he was counseling. He had received 4 years. The reason I'm telling you the history to this is because my colleague, I was in fact presiding on that matter, and I didn't think there were any grounds to interfere in the sentence. On appeal to the Supreme Court of Appeal, the sentence was changed from one in terms of section 276(1), which is the sentence that we had imposed, in other words, 4 years, and you would qualify for the normal parole after the initial parole period had expired. And it was changed to a 276(1)(I). Now, I is simply it's the same duration of sentence, but it gives a discretion to the Commissioner for Correctional Services to release the particular accused after having served a sixth of the period. I had thought the sentence initially imposed was one that was balanced. It was imposed by a regional magistrate who was steeped in the atmosphere of the case, and having regard to the nature of the offense, and particularly the violence against women and children, I thought the sentence entirely appropriate. But yes, sentencing is a personal issue. It was changed on appeal, and I unreservedly accept that. But to answer your question, do I see things changing in the immediate future? No, I don't. At times, as a trial judge, I can tell you that the provisions of the Criminal Law Amendment Act of 1997, that's the so-called minimum sentence legislation, at times does, I think, fetter a trial judge's or trial magistrate's discretion, perhaps, but we compensate for it and hopefully arriving at a sentence which is fair, allowing for an opportunity for rehabilitation, and then in due course, either for release on parole after a hearing before the parole board, or then in the section 276(1)(I) situation.
No, thank you very much. I don't have any further questions, CJ. Thanks.
Thank you, Commissioner Nsweni. Commissioner Khanyan.
Chief Justice, thank you so much. Good afternoon.
Good afternoon, Commissioner.
Judge Kun. We have a problem in this country which our president has described as a pandemic emanating from the misanthropic deeds that we see almost on daily basis being committed against women and children. And I'm not saying that you must give a judgment here or your opinion, but the question that I want to ask is, as a citizen of this country, what do these things say about our law and our country? Thank you.
I think a serious consideration in our country when it comes to crime is detection and successful prosecution. I always say that as a judge or a magistrate even, we are prosecutor driven. The judiciary as such cannot do much other than impose sentences which will hopefully act as a deterrent. But to reduce crime, and particularly also gender-based violence, the solution really lies in a higher level of detection. In other words, not having these high rates of rapes being reported, but only a very small percentage of them going to court. And then obviously, as and when suspects are detained, having been identified through an elaborate and comprehensive detection process, we must look at a higher rate of conviction. But, I can only, as a judge, contribute on that. I can only convict if I'm satisfied that there's evidence beyond a reasonable doubt. Accused persuades me that his version is reasonably possibly true, he's got to walk. He's to be found not guilty because that is what the judicial process requires. So to reduce the amount of crime, I think it lies more at the level of law enforcement, detection, successful prosecution. I hope that answers your question.
Are you satisfied, Commissioner?
Can I have a bite again, Chief Justice? Judge Good, the women of this country have, or let me say the social relations in this country have put women in the receiving end for centuries. If you know, we've said they suffered oppression 3 times or more than that.
Yes.
By extension. And if we continue to have inhuman acts like these ones, what do they say about our society? Where we now have a constitution that guarantees fundamental human rights to all its citizens, but they continue to suffer, being killed every day, being molested. What is the message that is being communicated or being put across to us as a nation?
No, I think it's a terrible message, and they're being let down. I think the judicial process certainly tries to do what it can. There needs to be. It's an enormous problem. It's not just a judicial problem. It's partly law enforcement problem, but it's also societal values, attitudes towards women, an economic dimension to it. It's a very complex problem without a speedy solution. But that doesn't mean that it shouldn't be worked on constantly, because as you rightly say, fundamental to what our new order since certainly 1994 is a constitutional state. And it's just anathema to have a situation where people are exposed to this level of violence when we have guaranteed rights. But the problem is to realize those rights.
Thank you. Commissioner Hassan?
Thank you very much, CJ. Judge Kun, my name is Fasiya Hassan.
Good afternoon, Commissioner.
JSC Commissioner from the National Assembly.
Yes.
I have two questions for you. I think let me start and preface the first by saying it's quite clear from reading the paperwork that your experience is not in question. In fact, as reading it, I came across a number of cases that while I was training to be a lawyer, which I never became, there were a number of your cases cited in a number of different textbooks. So I think that's the first important point to mention.
Thank you.
But the question really that I'm interested in are the measures that you might have put in place to contribute towards the empowerment of lawyers as you were coming through the process, and whether any of those types of empowerment also contributed to the transformation of the judiciary and the sector. I'll start with that question, CJ, and then ask the other one because it's unrelated. Thank you.
All right. If I may answer it this way, I think you might have picked up from the answers to my questionnaire that my slant, certainly initial in law, was more academic and lecturing. I started lecturing at the university part-time while I was at the bar. I also lectured every year to the article clerks at the Article Clerks Association as the article clerks were coming through. That was probably for the best part of the 1990s to early in 2000. I maintained right from the time of my start of my pupillage in 1988 an active interest in pupillage and preparing pupils for their bar exams. I lectured the motion court parts thereof, the ethics parts thereof. At the same time also, I did my fair share of having pupils that I trained, that spent time with me. And I'm very, very happy to say, very proud to say, that many of them have done extremely well. You would have seen that the chairman of the bar who nominated me was in fact one of my pupils, Mr. Mtembu SC. Very successful practice. He's acted with me in KZN, sat with me, and he will make a fine judge when he's appointed. Prior to him, the previous chairman, Mr. Naidu SC, Vanessa Naidu, is also one of my pupils. Another pupil was Mr. Nati Mtlati, who ended up, unfortunately I've lost touch with him, but he ended up as the last time I heard, as the Director of Public Prosecutions in the Eastern Cape. I think he's based in Makanda. It wasn't just across racial lines that I had different pupils, also across gender lines. I had a very successful pupil, Rita Nell. Regrettably, she was killed a few years back in a motor collision at Nottingham Road, because she also would have done well. I still, to this day, twice a year, or when the pupils at the local bar reach that stage of their progression, I conduct the moot courts in one of the real courts in the court building, and they come and they address me on motion court matters and appeals and the like. So my involvement in trying to transfer skills, to enrich, to motivate other young practitioners, mainly has been along those lines that I've briefly outlined to you.
Sorry, Chief Justice, I just want to make sure that the candidate answers the right question. If I can just follow up. I think, Judge Kun, when people say, what is your contribution to transformation as an advocate, what they are asking is whether you have brought Black people and women as your juniors.
Okay. I left the bar in 2006. The system of deviling, as it has been expanded upon a lot more by now, was still very much in its infancy. I didn't have much opportunity to do that. In fact, my last year and a half before appointment, I'd been acting and was away from the bar, so I didn't have much opportunity in that respect. But I certainly understand the value of that, and I'm delighted to see that it's being utilized more and more now.
No, sorry. What do you mean you didn't have an opportunity for that? You were a senior counsel for a number
Yes,
of years.
but it wasn't that general that it happened at that stage to involve juniors. Where it was being done then, it was the exception initially in those early years. It was still something that was being built on.
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Justice Kun.
Good afternoon, Commissioner.
I do just want to follow up on that, Justice Kun, because I'm a bit concerned that you reduce bringing Black people into matters to deviling. And I think we mustn't conflate the two.
No, sorry. When I use deviling, I use it as an abbreviation for getting the person involved in the matter.
So we're talking about the same thing, bringing juniors onto your matter to substantively assist you in your matters.
That's right.
And you're saying you never did that?
I can't recall having done that. I might very well have, it's 18 years plus back, have involved in the preparation of some matters, pupils or then very junior practitioners who had just started at the bar. But if you had to ask me which particular case number, I can't remember it then.
Thank you, Chief Justice.
Is the follow-up question? You already had your...
It's
your
my
quota.
second question.
Oh, you asked one? Okay.
Yes.
You can ask your second question.
Thank you, CJ. I wanted to separate it because they were different matters. Thanks, CJ. I'll try and be fast because I am aware of time. And I'll caveat my question by saying I have read the transcript of the May interviews. Of course, I was not a JSC commissioner then, but there are some questions I think are important, at least for our conscience to ask, so that when we deliberate later, we just have a full understanding. Judge Kun, I'm very interested in your thoughts around how the judiciary deals with Stalingrad tactics in attempt to circumvent, let's say, justice more broadly. I understand and I've read everything else, but I'm very interested around that. And I'm also very interested, at the time of the previous interview, you had the S versus Mhlongo case. I'm also just interested in the status of that. But more importantly, some of your views on the Stalingrad tactics and the wastage of money and time, and of course the role the judiciary plays, in some ways the last line of fire, so to speak. Thank you.
Yes, the two parts, I'll deal with the easy one first. S versus Mhlongo that I referred to was a part-heard trial, which was disposed of, sentenced, and the accused elected not to bring an application for leave to appeal. So I beg your pardon, that's done, and it's water under the bridge, so that's finalized. Stalingrad is a topic on its own. Stalingrad, lawfare, all those different procedures that are often resorted to by people who either want to eliminate opposition through lawfare, for example, litigate if you've got the deeper pocket, and just make it impossible for the other person to sustain opposition, or then Stalingrad really being a phrase that's been coined to also to avoid the end result by introducing all kinds of interlocutories or procedures. The primary problem, I think, with Stalingrad is the question of availability of appeals. As long as there are appeals and a person has a right in law to appeal, then it's very difficult to close the doors and say, well, it's got to stop here, unless you can show that it is clearly mala fide or an abuse of process. But that is not something in our constitutional dispensation that I think a court should lightly conclude. So the opportunity for a court to say, yes, Section 18(1) of the Superior Courts Act provides that you can appeal, but I'm going to deny you that appeal. I'm going to conclude that what you are doing is in fact mala fide, that it is it's an abuse of court process is not a conclusion to which a court can likely come. I'm not saying that it's always impossible, but it certainly normally will involve a number of initial procedures or appeals, firstly being entertained, unless there's clear evidence to the contrary. So it's difficult for, the answer or the expected solution might be, this is just an abuse of process. The principle is easy. To find the application of the facts is difficult. So it's not always as easy to quell those things, but there might, as it develops, because our law permits a number of appeals at different stages, and perhaps in due course the Law Commission or the Law Reform might look at limiting the number of stages of appeal that are available. I did just a rough calculation the other day. In an appeal from like a regional court, one can end up with a situation where almost, I think, 18 judges eventually, taking it every step through the appeal process, would have considered that appeal, and it would have gone through something like 6 or 7 stages, all with delays. So it's a combination. I don't think I can give you the answer. There's no simple answer. I can't just say to you, well, there's the solution. It's a lot more encompassing than that. But it's something that should be perhaps considered. Well, not perhaps, should be considered.
Commissioner Breitenbach.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Breitenbach.
So following on from the previous question and dealing with stolen great tactics, particularly in criminal matters, do you not think that what's required is a little more boldness from the bench?
Yes, it can involve more boldness. Well, when I say boldness, I'd hate to equate boldness to a sort of a recklessness, if that is the imputation. I'm very happy to say that the test remains the same, and perhaps the more consideration must be given when applying the test. But to me, the problem lies with, even if, using the term boldness, even if application for leave to appeal is refused, there's another step that's available. And there's another step available if that's refused. And you can go right up to the Constitutional Court. And the Constitutional Court judgment can be taken, an application can be brought for it to be rescinded. And that's really only when we get to the ceiling. So what I'm saying is that perhaps the solution lies in reducing the number of stages that might be available to a disgruntled accused who's been convicted. Because after all, what we're looking at as laws, as a system of rules, it's a system of rules that society subscribes to in order to ensure that there's orderliness. It doesn't necessarily always arrive at the right conclusion, but one needs to have a process, a procedure, where if there's a fault that is made, a mistake, or a misdirection at one level, that there's a stage to correct it. But perhaps the solution lies in getting to a point and saying, if you reach that point, your appeal's final.
Okay, I go along with you on that. What I had in mind more was during the course of a criminal trial, all of these interlocutors, all of these applications for review, and the bench seems to just, for want of a better word, cave every time. And so criminal matters run on for years and years and years, and there's absolutely no reason. If the bench, in my humble view, was a little more bold, then you could not get away with that kind of behavior. That's more of the question I'd like answered.
Yeah, I think the answer lies, or the answer to your question perhaps, in what criteria are taken into account. As the law stands at the moment, judges apply those criteria in accordance with their oath of office. And where they've granted leave, I believe they would not have done so if they weren't required by their oath of office and the application of the legal principles to do so.
I have one more question, please, Chief Justice.
Okay.
Judge Kuhn, I'd like to revisit the issue of the recusal in the Zuma matter.
Yes.
I know it was flogged almost to death the last time. But you actually got it right. I mean, you got the law right. All your decisions in that matter were right, and you were vindicated in every court thereafter.
Yes,
And so,
the
in
very issue.
retrospect,
Sorry.
with the luxury of an armchair view, which I understand is a luxury, would you perhaps decide differently in that matter today? Would you still recuse yourself? Bearing in mind that the recusal has set that case back 3 years, a case that's already 20 plus years old.
Well, with respect, I take issue on the last statement. Another judge was appointed shortly thereafter, and the delays that have ensued have not been because of the recusal. He could have proceeded and dealt with it. He had his reasons. He had things that were placed before him. There was a full court application, I beg your pardon, the full court hearing regarding the private prosecution, as you know. And interestingly enough, the very grounds that I had raised, that I said would place me in a position that I couldn't see my way out other than to recuse myself, were in fact the very grounds that were advanced in argument before the full court. They were rejected by the full court, but nevertheless, at the time when the recusal was being dealt with, they were findings that had been made. And in those circumstances, a person in the position of the accused having to argue the points that came before the full court eventually would have said, well, I cannot proceed before this judge because he's already firmly disclosed what he thought about my arguments. But I accept that recusal is a personal matter. It's personal in the sense of it involves a lot of conscience too. Courts will differ on it. People will differ on it. But at the end of the day, it's the importance of the judicial process remaining intact and being respected. Thank you.
In the 18 years you've been a judge, how many times have you recused yourself from a matter?
Once. This one.
Okay. Commissioner Trolley?
Thank you, Chief Justice. Judge Kun, at the start of the interview, the Chief Justice conveyed some compliments from colleagues and that described you as a fundamentally good person, and understandably you showed appreciation for those compliments.
Thank you.
Ironically, the former Chief Justice, Mogoeng, had some less than complimentary comments to make about your character and said, quote, if I've got the quote right, he wondered how you'd been made a judge in the first place. How did that make you feel?
No, I dealt with that at the second time that I came before this body, and I said it left me gutted. I couldn't believe that it was said. And I don't want to delay you or this commission today. The Bar Council and KZN and the Society of Advocates all came out with press releases. The meeting to which the former Chief Justice, Justice Mogoeng referred, a judges' meeting, had in fact been recorded. The recordal transcript was circulated. It came into the possession also of the press, and the reports at the time were that he had mistaken me for another judge. And as I said at the second time, the first time after that I appeared, and in fact Justice Meyer was presiding, I said that I accepted that a mistake was made, that I had been mistaken for somebody else, because number one, it is not my character. Number two, the transcript of that meeting where I was alleged to have acted in such a way showed the contrary. And I was not going to, it's water under the bridge, we must move on in life.
Any more questions, colleagues? Commissioner Mangan?
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon.
Yes. I just want to converse with you the aspect relating to the transfer of skills. You were asked questions in relation to the period when you were the silk, about the transfer, your engagement with black female advocates at the bar. Am I not audible?
No, that's fine.
Okay. Now, you said you can't recall, and I accept that. But then I need to ask you questions relating to the time that you were a judge. In the 18 years that you have been a judge, what programs have you engaged yourself in, alone or together with other judges, to train young and aspirant judges, either in your division or through Sajay?
Sajay is by invitation. I haven't been asked. I've been approached at a conference this year in Durban by a person who asked whether I would consider making myself available, and I said I would. Apart from that, we have meetings of judges in our division, and from time to time, the last one that I can recall now, dealt with preparation of for a large opposed motion, and we have a lunch as judges on a Thursday, and once we've had the lunch, I would then address all those present, which will be acting judges, the whole spectrum of junior judges, even up to senior judges, about how I go about preparing and what I do in my preparation, with the intention, that's the reason why our judge president has that, to to impart and transfer skills to the more junior colleagues and those acting who have aspirations to apply.
Now, that's encouraging, but you'd also accept that you do not need any authority to initiate certain programs, more especially when you need to train other people in your division. All what you need would be a proper coordination with your JP.
Yes.
That there is this program that you want to run and run it past her.
Yes. Yeah. No. She governs and manages this, and whenever I'm asked, I'm more than willing to participate in it. You know, we're not as judges in a position of, as much as there's seniority, of me prescribing to junior colleagues how to go about things. The principle is primus inter pares, all the same. If I had to say to you as a junior judge, you must come, I'm giving training this afternoon, it might be taken as offensive, because that judge has standing as much as I have with 18 years. Whether you've got 18 days or whether you've got 18 years, you're a judge. So it has to be organized, I think, also just from orderliness, from a central position.
Fair enough, and that's all, CJ, except that I can compliment Judge Kuhn on the judgment that he delivered on the 1st of October on the appealability of interim orders.
Oh, I see, the shipping matter,
yes.
MV Smart.
Yes.
Yeah, that's just been handed down in the Supreme Court of Appeal. Yes.
Yeah, it's a beautiful
Indeed.
judgment.
Thank you.
That was not a question, Commissioner. Commissioner Marumokhai, do you have questions for the candidate?
Yes, I have more of a comment, CJ.
We allow only questions, Commissioner.
I will frame it as a question.
Okay.
Thank you very much, CJ. Judge Kuhn, I think, well, I'm concerned about the transformative issue, but I will leave it at that because it has already been done. But I want to deal with this recusal issue. I hear often when people are talking about recusal. And my question is, when one looks at how you dealt with the issue of recusal and how you applied the test of recusal in Zarfu and other cases, did you apply it correctly or incorrectly? That's the question. But nonetheless, I just want to say this after having posed the question. I think an impression should not be created that judges should not recuse themselves. Because the debate seems to be that judges should only recuse themselves in circumstances, which might be true. But I just want to ask you, do you feel like in your judgment, you applied the test for recusal correctly? Thank you very much.
Yes, the short answer is yes, for the reasons I've given in the judgment. And I certainly would not have taken the step of recusing myself had I not concluded that that was inevitable.
And in my view, you were correct. Actually, I agree with your approach and your reasoning. Thank you very much, CJ.
Thank you.
Thank you, Prof. Judge Kun, it looks like we have reached the end of your interview. I don't see any further hands.
Thank you, Chief Justice.
Thank you for not giving up on this process and coming back to subject yourself to our questioning.
Yes.
I wish you all the best. You're
Yes, thank you. No, I thrive on the work at the SCA, and I feel I can make a contribution, and that is what has brought me back. But obviously, there would be an end one day to that as well.
Yeah. No, thank you so much.
Thank you.
Okay. Which one? These are the comments and the questionnaire. I didn't print one. Good afternoon, Judge Mchali.
Good afternoon, Chief Justice and the commissioners.
Are you comfortable?
I'm trying by all means.
No, just relax.
Thank you, Chief Justice.
I must start by declaring that you and I have known each other since we're young women. We have a relationship that is closer than the usual one between ordinary colleagues. but that does not mean that you'll be getting any special favors from me. You hold 3 degrees, a BA Law and LLB from the University of the Western Cape, and an LLM in commercial law from Cardiff University in the UK.
Yes, Chief Justice.
You started your legal career in prosecution in 1989.
That's correct, Chief Justice.
As a public prosecutor, then worked your way up to state advocate, senior state advocate, and in 2003, joined the Special Investigating Unit.
That's correct, Chief Justice.
Until 2008.
That's correct, Chief Justice.
And your judicial career began after you had undergone the former Minister Bridget Mabandla Aspirant Women Judges training program.
That is correct, Chief Justice.
So you are a product of that program?
Yes, I'm a beneficiary. Thank you, Chief Justice.
And soon after that, undergoing that program, that training, you were offered an acting stint as a judge in the Northern Cape Division of the High Court in Kimberley.
That is correct, Chief Justice.
How long were you there?
I was there from July 2009 right through to end May 2010.
And then you acted at the Land Claims Court.
That is correct,
After
Chief
leaving,
Justice.
immediately after leaving Kimberley.
Yes, Chief Justice.
Well, but for a term?
It was from June right through until the time I was appointed on the 31st of October 2010. But then I carried on until end of December
But you were
to
appointed-
finalize whatever I was doing there.
All right. Having been appointed to the Eastern Cape Division.
That's correct, Chief
Mthatha.
Justice. Yes, that's correct, Chief
Right.
Justice.
So you've been a judge since 2010?
Since 2010, permanently.
Permanently?
Yes,
And- But
Chief
you had a year acting in that position under your belt?
Yes, Chief Justice.
You have also acted at the Supreme Court of Appeal.
Yes, Chief Justice. That was in October 2022, right through to the end of November. And then again, from the 1st of June this year up to the 30th of September.
So that is 2 terms
Two
now?
court terms, yes,
All right.
Chief Justice.
When does the current stint end?
It ended on the 30th of
At the
September.
end of this third term?
Yes, Chief Justice.
All right. You've been before this body before, and it appears that the concern on the last occasion was that you may not have acted at the SCA long enough and had not acquired enough appellate experience. What would you say to well, it's not a perception, it's palpable, it appears from the questioning. That was
Yes,
put
Chief
to you.
Justice. What I can say with regard to that is that I have now been invited and accepted invitation to act in that court from 1st June right through to the end of September. I was involved in 12 matters in that court and allocated 2 judgments to write. Unfortunately, one matter in which I was a scribe had to be struck off the roll. But I have written a judgment in another matter, and I've also written a judgment which we are co-writing as colleagues. But the unfortunate thing is that those judgments they are still in the process.
they have not been delivered. But my involvement in the 12 matters that I was involved in gave me enough opportunity to learn and edify edify my experience in that court. In addition to that, I have been a judge now for more than 15 years, sitting on appeals. I have been at times a presider. I've sat in full bench appeals. I've lost count. Ever since I started acting in 2009, this has been the practice. I, as such, I'm of the view that I have accumulated sufficient experience to make a contribution to that court.
So you don't have a judgment in the Supreme Court of Appeal as yet?
I have two that I mentioned in my questionnaire, which were delivered during my last stint in the SCA. One of them being S versus Zondi, and then the other one was Ricardo Spani. Those were delivered during my last stint. Unfortunately, during this stint, although I circulated my judgment soon after, it was, I think, about a week or two after we sat, I'm still awaiting comments from colleagues.
How many judgments have you written on estimate in the High Court?
Sure.
Reported and unreported?
CJ, they would be in excess, I think, of 200. I'm just thumb-sucking. I have not kept count of how many judgments I've written, but in the High Court, that happens on a regular basis.
How many of those reported, if any?
I note the GCP has mentioned some judgments which I didn't check as being reported. They mentioned 3, I don't know. And then there was one that formed the subject matter of discussion in my last interviews, which is the Kohtliso matter, which went up to the Concord and confirmed. There's also a Ndabeni matter which features in my profile as being, which was confirmed by the Concord. I have not kept track of how many reported judgments I have.
But you say it's a number?
Yes, Chief Justice.
Do you have any outstanding judgments, reserved judgments that is sitting there?
Chief Justice, except for the judgment that I mentioned as in my questionnaire, in which I'm not a scribe but a colleague, I have no other reserved judgments.
Did you get a chance to write during your acting stint in the Land Claims Court?
Yes, I wrote some judgments in the Land Claims Court.
Well, I'm relying on the list drawn by the GCP, but they don't say it's a closed list, so one does not know.
Yes, they said they managed to get this
Hold of these ones.
the list that they've
All right.
given.
All right. Thank you, Judge Mchali. I will hand over to Deputy President Zondi to put questions to you if he has any.
Thank you, Chief Justice.
Thank you very much, Chief Justice. Good afternoon, Judge Mjali.
Good afternoon, Deputy President.
I'm not sure whether it was a mistake on your part. You seem to have completed the wrong form. The questionnaire that you completed is a questionnaire for people who are still applying for judicial appointment, not for judges. You see, there is a questionnaire for judges. Your question at page 9, it's question 9 of your, it's written, paginated page 9.
Yes, Chief.
It says questionnaire for candidate for judicial appointment, but the form that I think that you should have used, it's a questionnaire for judges. Well, the reason why I'm asking this question is because some of the question which, well, arising from the question that were put by the Chief Justice, if you had used the correct form, that information would have been supplied, like judgment that we have written, judgment that were successfully appealed against, judgment that were dismissed on appeal. That information is lacking in that form. So it's, I think that using the wrong form did not help you to sort of market yourself.
Deputy President, I looked at the advert. This was my question too. The advert directed us to this very form that I completed. And I wondered, I saw the difference in the forms, but I wondered why. But this was the form that was attached to the advert.
And well, some of the concerns that were raised by my colleagues at the SA was that you hadn't written sufficient number of judges from which one can assess your suitability. I'm sure it was based on the information that you provided in this form.
Come again, Deputy President.
Well, sorry. One of the concerns that was raised by some of the colleagues at the SA was that you haven't written sufficient number of judgment which one can use to assess your suitability and readiness to be appointed. And I'm sure that comment might have been based on the information that you supplied in this wrong form, because if you had used the correct form, that information would have been reflected here. Like, I've written so many judgments, I've got so many judgments that were taken on appeal, so many judgments were dismissed on appeal, so many judgments were upheld on appeal. So that information seems to be lacking in this form.
May I again refer to the advertisement? I blame that on the advert because that's the form. The form that I completed is the form to which we were directed. Previously, on the previous two occasions I had to come before this body, I completed a different form, but I thought things had changed when we were directed to this new form. And the information that I supplied when I applied initially I thought it would be on record before this body.
Yeah, okay, that's fine, fair enough. And the other thing that they raised was you haven't acted at this SCA long enough, and do not have sufficient experience. What do you say about that?
Deputy President, my response there too would be, I have only been invited to act 2 times in that court. And on both occasions, I never refused. I accepted the invitation. The unfortunate part is I can only act in that court upon invitation. And I acted in that court. On the first occasion, I managed to deliver 2 judgments. On this occasion, I mentioned that my judgments, where I had to write, were circulated timeously.
Well, other than that, I've sat with you and your contribution to the debate during the hearing was very constructive and it facilitated the conduct of the hearing. Thank you very much, CJ.
Thank you, Deputy President.
Thank you, DP. Commissioner Matolo Dlepu.
Thank you, Chief Justice. Good afternoon, Judge Mutali.
Good afternoon, Commissioner.
You know, one of my concerns was, I understand maybe you've completed the wrong form, but the same wrong form that you completed, I'm looking at paragraph 11.1.
Come again, Commissioner?
I'm saying, even if I have to give you the benefit of doubt, the same wrong form, paragraph 11.1, section 2, it says the legal background. Please outline your entire career in law, giving an indication of your principal areas of legal interest and involvement. Then you respond and say C6 above, paragraph 6 above. When one goes to paragraph 6 above, it does not tell us about your areas of law that you know, I'm just thinking that maybe you paragraph 6 above, you say you worked in the Department of Justice. Those are not the areas of law. I mean, I'm just trying to think because this is not the first time you came in. What happened?
Commissioner Dlepu, I was a public prosecutor from 1989. And that's criminal law. Senior state advocates, it's all criminal law, special investigating unit that involves it's not criminal law, it involves giving legal advice. I was a legal representative there who had to channel investigations and give legal advice. And then there was OCJ, the Judicial Training Program, and then as an AJ. I thought that outlines my career path.
A follow-up, I just think you did yourself an injustice by not reading the question. Even if it's a wrong form, what you are describing now is what you should have completed and said, these are the types of law. That's what we want to say, because you are going to the SCA.
I take the point, Commissioner.
Okay.
Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Justice Mjali.
Good afternoon, Commissioner.
On the topic of doing yourself an injustice, Justice Mjali, last time that you were here, both Chief Justice Zondo and President Monimela spent some time taking you through your selection of judgments and why it is that that selection is so important. You know, the JSC sees that as an occasion for you to showcase your capability, the depth of your experience, and the kinds of matters that you've written on. Now, against that, and I don't know if you recall that that was covered in your previous interview.
Yes, I recall that was covered. It was question 9 point.
Now, against that backdrop, you put up the Ndabeni decision. It's the first judgment that you referred to in your application.
You mean, are you referring to the last questionnaire, the last time?
No, this time round. You put up the Ndabeni judgment. I think it's
Are
the
you
first
referring
judgment.
in which?
If you look at page 25, paginated page 25 of your bundle.
Yes, Commissioner.
Now, there's a number of issues that we can raise with the Ndabeni judgment. Let me just suffice to say this, Justice Njali, you put up a judgment that's made up of 6 paragraphs. The bulk of the judgment is dedicated to establishing that the matter is unopposed. And really the only reasons provided in the judgment comes right at the end of the judgment in one little paragraph where you say that the applicant's version is unopposed and there's no legal impediment to granting the order and therefore you grant the order.
Which paragraph are you referring to?
It's the last paragraph of the judgment, it's paragraph 6. So everything that happens before paragraph 6 is just to establish that the matter, that there is no answering affidavit before you. There was a Rule 30 filed at some point, but the Rule 30 was abandoned. You see that, Justice Njali?
Yes, I see that, Commissioner.
So really the only thing in your judgment is your paragraph 6, where you say that there is no opposition. In other words, the matter is unopposed. The only version before you is that of the applicant and that there's no legal impediment to you granting the declarative sought.
May I just comment about the Ndabeni judgment?
Yes.
This is the judgment that went through scrutiny, through the SCA, through the Constitutional Court. I've given my reasons here that if one looks I must have given my full reasons in the application for leave to appeal, because I must have written this one in haste. There is a judgment on the leave to appeal that went through the SCA, and there it was subjected to a lot of scrutiny, and as such, partly overturned by the SCA and then confirmed by the Concord.
So all I'm questioning, Judge Njali, is why it is that you would include this judgment as a sample or as a showcase for you of your judgment writing.
It's a judgment. I must have made a mistake not to include the application for leave to appeal, because that one, that's where I elaborated on these issues. This one was done in haste just to give reasons for judgment. And then when they appeal for leave to appeal, I gave them full reason. And that is the appeal that was taken to the SCA and confirmed. In the reports, you will get the remarks that my judgment was subjected to scrutiny, and the SA found no reason to tamper with my judgment except for paragraph 2 of the order. And the Concord went to the same scrutiny and found my judgment to be sound, and there was no reason for the SCA to have tampered with paragraph 2 of my order.
So if I understand, Judge Njali, you're saying that the real judgment you would have wanted to showcase is your judgment on leave to appeal?
That is correct. I must have, because I did this in haste. maybe I should mention this, that I had no intention of putting in an application this time, but I had to be, at last moment, collate something to be put in after a lot of pressure was exerted on me.
Can I just say this, Judge, these little things, completing the correct form, putting up the correct judgments, they all carry real significance because when we consider your application, we do it well in advance of you appearing at the interview. So I just wanted to raise that issue with you.
I take the point, Commissioner. Thank you.
Thank you, Chief Justice.
Thank you, Commissioner Pillay. Commissioner Mangan?
Thank you, Chief Justice. Good afternoon, Justice Mujal.
Good afternoon.
Yes. I need to follow up on this statement. Are you appearing before this commission on your own volition or under pressure of someone else?
No, it's not under pressure. It's responding to the call to serve.
So as you respond to that request, you had to act in a rushed manner.
Because the time, Commissioner, was close to closing time.
Okay.
And I asked my secretary to collate my judgments. I gave them and assumed if Commissioner, you would look at my last papers that were submitted before this commission, the application for leave to appeal was fine. That was the correct judgment. So the error.
No, it's fine. I'm not really on Davini.
Yes.
Here comes my question. May I draw your attention to page 16 of the
16.
Yeah, 16. It deals with your question.
Yes.
Paragraph 9.4. There's a question there that asks, have any of your judgment been taken on appeal? Indicate with an X. And you answer there, yes. And the next question is, what was the result of the appeal? And you say the appeals were unsuccessful.
Can we read that question in context, Commissioner?
Yes, I wanted to do so, but in the context of time.
The context.
Yeah, I
That the
started
context
where-
there is, did you act in any division? It starts in page 9. This is question 9. If you have sat as
saw
an
that,
acting judge.
I saw that.
Thank you.
It asked you when you were appointed, you said Northern Cape, in which year, and you mentioned 2009 up until 2010, and you made mention of the Land Claims Court. But the import of the question is, have you written judgments and have any of those judgments?
As an acting judge.
No, I don't know where you take the
It's
acting judge.
9.4. It's question 9.
Yeah.
If you have sat as an acting judge, 9.1, in which division were you appointed? And I answer in that context. I sat in the Northern Cape High Court Division as an acting judge, Kimberley, and as well in the Land Claims Court. That's why I do not mention the Eastern Cape, because I'm answering this in the context of an acting judge.
So,
And then it goes now, 9.2, please give dates of appointment. You will note in 9.2, I've given dates as an acting judge.
So seated here today, have any of your judgments taken on appeal?
I have judgments that have been taken on appeal. In my last form that I completed, I mentioned which judgments. And this was the subject of a discussion with the president of the SCA. She said I mentioned only 2, and she found a third one, which judgment turned out that I was not the scribe there. Yes, I accepted responsibility because I was the presider. That was the judgment that was taken on appeal and overthrown, which I had not mentioned in my questionnaire last time. I mentioned two. It's on record before this body that I mentioned two judgments that were overthrown. One of them being Hahoff, and the second one being Hulumeni versus the Democratic Alliance. That was it's termed in the media the toilet interview case. That was the judgment I was overturned in. I mentioned the two Hahoff, I dissented there, and that judgment went to the SCA, but the SCA did not agree with me.
Thank you, Judge.
Thank you.
Commissioner Baloi, I forgot about you.
Thank you, Chief Justice. Good afternoon, Judge Mujali.
Good afternoon, Commissioner.
Yes, Judge, the difficulty that I have seems to be an issue of lack of attentiveness on your part. You applied last round, so you know the form that must be completed. The form that you completed on its face is obviously not suited for you. And I must say that it's uncomfortable sitting here that of the candidates that we've seen today, you are the first candidate that has completed the wrong form. So when you say that you were directed to the wrong site to the wrong form by the JSC, I'm not sure that we should accept that at face value. We have to ask the question, what about the other candidates?
Thank you, Commissioner. Maybe what would save...
Maybe let me finish.
Let her finish the
Maybe let me
question,
finish.
please.
I'm expressing to you my concerns, and then you can comment after that. So there's that concern that you complete the wrong form, which on its face is clearly wrong for you. But this is not the first time you do this. In the sense of, it's not the first time you complete a form to be elevated to the SCA. I have listened to the discussion with Commissioner Pillay, where she discusses that the judgment that you put in, and then you answer. You're not dealing with the question that she's asking, and suggests, or what the proposition she's making to you, which suggests you're not quite attentive. But lastly, what also concerns me is you say you tasked your PA to put together your judgments, and you assumed that she has done it right. I would be extremely concerned that a judge of the SCA, which is appeal court, is happy to leave things in that way. You gave it to your PA, it means you didn't check it. It's one thing perhaps in the High Court where we all know we have a second bite in the appeal court, but to know that in the appeal court we would have judges that are not attentive to detail would be a matter of great concern to me, and I expect it should be a matter of great concern to people who litigate in the SCA. You can comment if you want to.
Thank you, Commissioner. Maybe what would save the day would be to look at the website, to look at the very advert. I queried this when I completed. The form itself was completed by me on computer. But then I asked my PA to bring my judgments, and then I looked at the judgments and thought that the judgments that I had attached last time included the application for leave to appeal. I had attached this judgment last time. I must have made an error in this regard. But what would save the day with regard to completing a wrong form? I would ask the Commission right now to look at the very advert and see which form we are directed to. There's no demarcation for people who are applying for the first time and judges who are applying to be elevated to another court. There's no demarcation there. I am certain about what I'm saying.
Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Marumakhai, do you have questions for this candidate?
No, none, CJ, thank you.
Thank you. Judge Mchali, I don't see any further hands. We have reached the end of your interview. Thank you for making yourself available.
Thank you, Chief Justice and the commissioners.
You're excused.
Thank you.